Good morning, viewers. Welcome to consumer shorthand classes. Get ready. 5 seconds. Start. Thus, the power conferred on the High Court under Section 482 of the Code is not exercisable so as to defeat any other provisions contained in the Code. Nevertheless, such powers may be exercised in exceptional cases to secure the ends of justice or to prevent abuse of the process of the court. The lines drawn between the two sets of cases is no doubt thin but all the same real. It is left to the good sense of the judges of the High Court to act any manner they decide. It must be taken as well settled that to seek interference under Section 482, three conditions are to be fulfilled, namely 1. The justice which comes to the light should be of a grave and not of trivial character. 2. It should be palpable and clear and not doubtful. And 3. There exists no other provision of law by which the party aggrieved could have sought relief. If a power has been taken away by the statute, or if the statute prohibits exercise of power that cannot be saved by resort to Section 482 CRPC, that would be to invoke the section to defeat the policy of law by permitting the exercise of what is expressly prohibited. The absence of definition of the limitations in the exercise of the inherent power is of no consequence and does not enable the High Court to exercise such power in any and every case as if interests of justice call for such exercise. The Code of Criminal Procedure embodies an exhaustive scheme for adjudication by courts. The trial, appellate, and revisional jurisdictions are indicated in the provisions of the Code, and the Code envisages finality for these decisions. That itself is an expression, direct and unequivocal command to the High Court that such finality should be respected. The limitation in the exercise of inherent power must necessarily be read in the scheme. If, nevertheless, the court sits in judgment over decisions conceived as final decisions by the Code of Criminal Procedure, the High Court itself may be said to be guilty of abuse of the process of court. The High Court will decline to exercise inherent power in such cases not because of absence of such power, but because of the policy of extreme self restraint the court has to impose on itself. The Supreme Court in Rao versus the state of Maharashtra has laid down the guiding considerations for exercise of powers under section 482 as follows. 1. That the power is not to be resorted to if there is a specific provision in the code for the redress of the grievance of the aggrieved party. 2. That it should be exercised very sparingly to prevent abuse of process of any court or otherwise to secure the ends of justice. That's all. మరి ఈ వీడియో గనక మీకు నచ్చినట్టయితే దయచేసి షేర్ చేయండి. అలాగే మీ అభిప్రాయాన్ని కామెంట్ రూపంలో పెట్టండి. అలాగే నా ఛానల్ని సబ్స్క్రైబ్ చేసుకోకపోతే సబ్స్క్రైబ్ చేసుకోండి. థ్యాంక్ యూ వెరీ మచ్.